The American legal system, at times, it feels like an archaic institution, a place almost separated from reality, run by the higher powers that be. Fortunate citizens usually only have brief interactions with the legal system in their lifetimes. Maybe it be through electing district attorneys or attending traffic court, or even watching Judge Judy on afternoon TV. But perhaps the most important role the average American can play in the legal system is serving on jury duty. Jury duty. Now, it's the letter everyone hates when they get in the mail. But the concept of jury duty can be traced all the way back to the Magna Carta in 1215. Now, in English common law, this council, separate from the court, was a necessary protection for the people. It was seen as a sort of barrier between the crown's overreaching power and the common man. Naturally, this was a concept that was widely adopted by many different types of governments. So the Founding Fathers of America included provisions within the Sixth Amendment of the Constitution, stating that the criminally accused were guaranteed a right to a fair and speedy trial by an impartial jury. This jury is now referred to as a jury of your peers. After experiencing a slew of unfair trials under the king, the framers knew that having a jury was a necessary protection against the government accusing their enemies of terrible crimes that just never happened. The concept of a fair jury has changed dramatically over time. Originally, juries were only made up of white landowning men. Now today, the legal system attempts to create a jury that represents a cross-section of the community, meaning that it includes members of all different belief systems, race, gender, and other sorts of protective classes. To do so, they have set different precedents, laws, and provisions in the beginning of the trial to find a jury that is unbiased in this way. To do so, at the beginning of the trial, each attorney is allowed to voir dire potential members, meaning they're allowed to ask different questions to assess the potential bias of each jury member. Then, if they sense a sort of bias towards their client, these attorneys are allowed to challenge these members. This challenge means they're allowed to ask for the removal of the potential jury member. Challenges for cause. Challenges for cause are used if the bias is clear on the jury member's part. An attorney may use the causal challenge if the potential jury member says things like, "I don't like police officers in general," or, "I believe if you were arrested, you're guilty." These challenges are then clarified to the judge, who decides if they are based on true prejudice. If the judge believes there were fair grounds to bring the challenge, the jury member will be stricken from the pool. These challenges are unlimited in number. Peremptory challenges. A peremptory challenge is the second type of provision. This is when an attorney may strike a witness from the jury pool and does not have to provide any sort of explanation as to why. This was implemented as a way to prevent bias from the judge, because it allows lawyers to make decisions about the pool that may differ from the judge's perceptions, but are very necessary for a fair trial. The caveat is they may not be used to strike a jury member because of their race, gender, or religion. As a precaution, there are only a limited number of peremptory challenges, but despite all efforts to limit the use of peremptory challenges in a prejudicial way, it still often occurs. One of the most notable cases that aimed to prevent prejudice was Batson versus Kentucky. In 1985, James Kirkland Batson was convicted for second-degree burglary. During his appeal, Batson questioned the prosecutor's use of peremptory challenges during the original voir dire. As a black man, Batson recognized that his jury was only composed of white members, and that during the voir dire, the only 4 black potential jurors were all struck down by the prosecutor with the use of peremptory challenges. The Supreme Court ruled that under the 6th and the 14th Amendment, racial discrimination during the jury selection process robs the defendant of their right to a fair trial. Thus, peremptory challenges could not be used to eliminate a person because of their race. In other trials since, they have occurred coming to the same conclusions for other protected classes. In JEB versus Alabama, the courts ruled that challenges could not be used to eliminate a person due to their gender. In SmithKline-Beckham Corporation versus Abbott Laboratories, the court ruled that the defendants could also appeal the use of peremptory challenges if they were done to eliminate a person because of their specific sexual orientation. All of this is done to make sure that peremptory challenges are not used for prejudicial means. Despite the efforts of the Supreme Court to eliminate all uses of biased peremptory challenges, it still exists today. We saw this most recently with the 2019 case Flowers versus Mississippi, which attempted to identify the uses of biased peremptory challenges after the fact. Now, checking the courts after the fact assumes that these attorneys are aware of their implicit bias, and also assumes that the judges can identify between honest and dishonest answers, when this is not always the case. But what can be done about this? Well, first, understanding the implications of the legal system is a very important step. If you are over the age of 18, make sure to educate your friends on how important it is to have a fair trial, which is a constitutional right. When you are summoned for jury duty, go to court. Take it as seriously as possible. And when elections roll around and local judges and the district attorneys are running for their positions, make sure to pay attention to how they are talking about discrimination in the legal system and their plans to eliminate it in the future. You see, change starts with you. So get involved, get educated, and never rest for injustice, because with you, things can be different.